Good morning, everybody, and welcome to this Garden Court webinar on economic migration issues during the coronavirus crisis. We have an hour and a half this morning, and we have four speakers. There's myself, Adrian Berry, and also Miranda Butler, Emma Fitzsimmons, and Mark Symes, and all of us are members of Garden Court Chambers. We have quite a packed hour and a half, and so we're going to go through things at a fair clip. We have a group chat box, as usual in Zoom webinars, for people to put their questions, and we may try and deal with some of them as they occur by written answer from someone who's not speaking, or we may have some time at the end as well, hopefully, for questions to be discussed. There are a couple of housekeeping points which I have to make you aware. Firstly, that we are you're going to be kept on mute unless you're actually speaking, and please keep yourself on mute if there's any problem at your end. Secondly, that we're actually going to record the webinar. Which means that any audio or video contributions which you make will be recorded along with those of the presenters. And the webinar may be shared with our marketing through our marketing channels or on our website or on social media, but no other audio, video or personal data will be recorded or shared. And what goes on in the chat is not recorded or shared. So if you want to make a contribution, by all means, please do so, but do bear in mind about the recording. So without more ado, I'm going to share my window with you, and then we'll start going through our material. So hopefully you can all see my screen at the moment. And we have, I'm going to start off by giving you just a brief overview of some of the issues which are occurring for all of our clients. And then we're going to drill into the details of the different areas of economic migration. What we have to start with, of course, is a crisis whereby certain people have either been forced as a result of coronavirus illnesses or because they're self-isolating to either overstay limited leave that they have to be in the country, to enter or remain, and would otherwise seek to leave because they're here for only a short time. Or we have people who are either seeking to come into the country for economic migration purposes for a more enduring length of time, either because they're on tier 2 visas, for example, or potentially they're here working and they're on family reunion routes and they wish to extend their stay, not just simply for a short period of time because they're unable to travel, but because they're on a path to more enduring classes of residence, often which lead to permanent residence in the UK. And what we've had with the Home Office response to the coronavirus crisis is a series of notices placed on the government website, changing their stance over time as to what they will be doing. And so initially on the 17th of February, there was an announcement to Chinese citizens only that their leave to remain would be extended automatically, and that they didn't need to do something. And then as the crisis unfolded and unraveled and developed into March, the Home Office changed their stance and said that those who are unable to travel of all nationalities, either as a result of being ill as a result of coronavirus, or because they're self-isolating on a precautionary basis, could notify the Home Office via the form, the Visa and Immigration form, for a short extension until the 31st of this month, of May, if they are unable to travel. And so that raised the question for people either who'd become overstayers because they'd been unable to travel, but then sought to complete that form online, or because they were coming up to the end of their period of lawful residence, their period of leave, what the significance was of filling in that form. And clearly, the intention of the Home Office is that it will provide you with a visa extension until the end of the 31st of May. But if you are planning on making an application anyway to stay beyond that point because you were on a track either to enter the UK or to remain in the UK for further periods of time, so for example on an extension of a tier 2 visa, then that may not be the form for you. And Miranda is going to deal with in-country applications which cover that sort of thing. So the focus of the form was on those who were unable to, whose departure, if you like, was imminent, and who were unable to travel, and there would be a short extension. But from our point of view, of course, the significance is, well, if you've already become an overstayer because you've been unable to travel, or you fill in the form, what does it mean? Do you get an extension of leave, or do you, so that you're not considered to have been here unlawfully if your leave's expired, or do you get an extension of leave if you're still in time and you fill in the form? It seems reasonably clear that the form is not strictly an application, but if you look at the 1971 Immigration Act, there is provision to extend and to vary leave under sections 3 and 4 of the Immigration Act. It can either be done by giving notice in writing to the person affected, but by the extension of leave. And it doesn't specify, of course, the Act was passed in 1971, long before the internet was widely available, it doesn't specify how you serve that notice in writing. Or more generally, you can do it by making an order by way of the Secretary of State can do it to a class of persons by statutory instrument. So it's entirely possible to extend leave to remain by a statutory instrument or by giving notice in writing. But what's striking is that there is only one example of a statutory instrument like that in force at present, which is one for persons who may be victims of modern slavery. And there hasn't been any statutory instrument to a class of persons affected by the coronavirus crisis. So there's no automatic extension of leave in that way by making an order to a class of persons. That leaves the issue about whether or not what's been posted online by the Home Office counts as a notice in writing to a person affected. And when one looks at section 4, it's clear that what's anticipated is that notice would be in essence to an individual as opposed to a class of persons. But there's no reason in principle why it couldn't be to a class of persons. The difficulty may come retrospectively, that the Home Office take note of who's filled in the form, but don't grant leave until later, or don't to the individual concerned, and certainly don't notify that person until later on. And then in years to come, when they come to, say, apply for residence under the 10-year route, they're considered to have broken under the long-term residence route. They're considered to have broken their continuity of residence because there was a period in which they overstayed before that leave was confirmed. And the Home Office stance is that no one should be prejudiced by the coronavirus crisis and their inability to leave. But whether those good intentions and those fine sentiments last and endure beyond the current crisis and are available to caseworkers in years to come when they come to disregard periods of overstaying remains to be seen. So the thing to bear in mind is to consider if your client needs to stay on a more enduring basis, that they should try and make an application in the ordinary way rather than relying on the short-term inability to travel form. I've given you on the slide that you can see now just reference to the immigration notices regulations, because unlike the power under section 4, they provide for formalities for serving a decision where it's appealable, whereas a section 4 notice under section 4 of the 1971 Act doesn't specify when it's given in writing that it should be, for example, by hand or in any other way. And so the important thing is to, if we do get into a debate with the Home Office as a matter of policy and in respect of individual clients in the time to come, to understand that's the sort of terrain that we're in. And if the Home Office consider that they have granted leave by giving notice in writing online, practitioners, both individually and collectively, may well wish to take the benefit of that and not quibble about it. But the law is not free from doubt about what those Home Office announcements online mean. And notwithstanding the lack of prescribed requirements for serving a notice to a class of person in writing, notwithstanding the absence of any particular service provisions beyond that, there is some doubt about what the status of those Home Office notices actually mean. And Mark's going to pick up on some of the public law issues that arise out of that at the close of our presentation. So that's the general overview. And then very briefly, I'm going to go on and just cover some sponsor license issues, which we need to think about, and in relation to economic migration issues, as we come in then to look at, to hear from Miranda about the in-country and out-of-country applications which people will be making. So here we're just having a brief look at what's changed in economic migration since the development of the crisis. So the thing to remember and to bear in mind is that sponsors are there's still Brexit in the background at the moment, and there's still the intention to introduce a new unified immigration rules set of provisions, as was foreshadowed in the Home Office white paper, or the Home Office published, or the Home Office policy paper published at the end of January, beginning of February, which seems like a very long time ago now, but does contain the Home Office vision, if it can be called that, for the system after the end of the Brexit transition period. And so that would include people employers who had not been sponsors hitherto, but who have a large number of EU citizens on their payroll who recruit from the European Union region, needing to become sponsors. And so one point to note is all of that continues, and that one of the planning issues for employers who have persons subject to immigration control on their payroll or potentially on their payroll is that timeline continues, and that planning for recruitment of staff after the end of the transition period needs to carry on as part of the post-COVID-19 planning as much as part of the post-Brexit planning, and so people need to bear that in mind when advising sponsors. There are then also a series of requirements in relation to what needs to be done in relation to reporting requirements for those who are currently sponsored at the moment. And so in a nutshell, what we have is, as far as reporting requirements are maintained as opposed to relaxed, what we have is you do have to report a delay to the start date of an employee or a student, although or a prospective student, if their start date is delayed as a result of the coronavirus crisis. But the innovation is that they can still start study or work even if the application is still pending. So that's the first thing. So the delay has to be reported, but they can start pending. They actually can start work or study, as the case may be, pending determination of the application. If a sponsored relationship is terminated, then that still has to be reported with a note that it was as a result of the coronavirus crisis. If there is a change of job title, that has to be reported. And if there's a change of salary, or if the business ceases trading or is insolvent. So those are still things which are, in respect of which there are reporting requirements. Where there's a relaxation of reporting requirements is where, for reasons due on account of the coronavirus crisis or as a result of the need to self-isolate, there is an authorised absences of 10 days or more from work, or 60 days or more from study. They do not need to be reported, but they do need to be noted on the sponsor's records as being due to the COVID-19 coronavirus crisis. And the same is true if unpaid leave of more than 4 weeks is taken. It doesn't need to be reported, but it does need to be noted by the sponsor that's occurred. And again, there is considerable flexibility from the Home Office in terms of working from home and distance learning. Tier 4 sponsors in respect of students are encouraged to monitor attendance if possible, but it is understood and that there will be issues arising whereby, through reasons of force majeure as a result of the crisis, that either people have to work from home or they have to study from home. So in respect of Tier 2 sponsored workers, the sponsors can reduce the pay of the person sponsored to either to 80% of their salary or to £2,500 per month, whichever is the lower, provided that reductions are part of a company-wide policy to avoid redundancies, and that the reductions must be temporary and that pay must return to previous levels once the arrangements have ended. In terms of the report given on the sponsor management system, it must be reported that the amount of salary has been reduced for how long, and that it is part of that company policy to avoid redundancy as a result of COVID-19 issues. As I've already noted in respect of Tier 2, but it's true in respect of Tier 5 as well, sponsors can allow a worker to commence work while awaiting a decision on an application if they've been assigned a certificate of sponsorship. The worker produces evidence that their application was submitted before their leave expired, where relevant, and the job that they start is the one that's actually stated on the certificate. Remember also that to keep up to date, sponsors need to keep up to date with any changes that impact upon the application in terms of the certificate of sponsorship. And also remember that once an application is eventually decided, if it's rejected or refused, then the person will have to cease working. In respect of Tier 4, there's some similar pragmatic flexibility. For higher education providers, they can self-assess the English language at B1 to the standard if the student can't take the test overseas as a result of the closure of places to take the test. And also a student, like a worker, can commence study in this case while the application is pending, where the Tier 4 higher education provider holds a sponsor license, Tier 4 sponsor license, and isn't a legacy license holder. They've assigned a confirmation of acceptance of studies to the student, and the student produces evidence that they submitted their application before their leave expired, and the course is the one actually stated on the confirmation. And where appropriate, if it's required, that there is a valid ATAS certificate. Although the Foreign Office aren't assessing or accepting requests for those certificates at the moment, if you call the coronavirus helpline, they may be able to assist in respect of that. Just to go through one brief list of final points in relation to both certificates of sponsorship and confirmation of acceptance of studies in terms of their validity. The Home Office approach, in quotations, is to take a pragmatic approach where the start date is significantly different, and also where those documents have become invalid and the individual has been unable to travel as a result of COVID-19. It may even be possible to use one of them exceptionally as part of a new visa application. And so it's clearly important to stay in touch with the Home Office when pressing for that. In respect, it is always going to be necessary for the applicant to confirm why they were unable to travel, and there will still be individual decisions on individual cases. This is not a general blanket approach in terms of the information on this slide that the Home Office are taking, but nonetheless, we're in the situation where where some flexibility can be shown, and the important thing is to make the appropriate representations and to be in touch with the Coronavirus Information Centre email address, which Miranda is going to cover in her presentation as well. And that brings us appropriately to Miranda's presentation, and she's now going to take you through out-of-country and in-country applications, bearing in mind the brief overview of the issues arising under Tier 2, Tier 4 and Tier 5, which I've just been through. Thank you. I'm going to take my slides off now, Miranda.
Thank you very much for that, Adrian. As Adrian's already indicated, I'm going to be dealing with out-of-country and in-country applications. What I'm going to be touching on are some of the issues for applicants overseas, some of the concessions made for applicants in the UK, particularly the temporary extension scheme that Adrian's already discussed, and the concessions for NHS and healthcare workers. So the most significant piece of Home Office guidance, from which most of the material that I'm going to be covering has been drawn, is the coronavirus advice for UK visa applicants and temporary UK residents, which can be found in the URL below. It might be thought to be unfortunate that the Home Office hasn't yet published more full and detailed guidance, and it's certainly worthwhile for practitioners to keep a very close eye on this webpage, which can be updated on quite an ad hoc basis. So we're going to start by talking about overseas applications. As I'm sure many of the attendees are aware, all UK visa and citizenship application centres and service support centres are temporarily closed. That doesn't prevent applicants from submitting online applications, but there won't be biometric appointments, and anybody who had booked such an appointment will have it cancelled and will be contacted in due course so that they can rearrange that when the centres do reopen. Fortunately, that fact shouldn't cause too much prejudice to applicants because the deadline to submit biometrics has been removed. Of course, there'll be some applicants outside the UK who hold either a 30-day vignette which either has expired or is about to expire. Fortunately, the concession for them is that they can request a free replacement visa with revised validity until the end of the year. In order to obtain one of these, it's simply necessary to email the Coronavirus Immigration Help Centre, which I'm going to be addressing in more detail later on, with the subject replacement 30-day visa, and then the details that I've provided there. When the local centre reopens, they will contact the applicant and arrange for a fresh endorsement to be made. It's also worth noting that there's, of course, no penalty for a failure to collect your BRP on time until the end of 2020. Very briefly, it might be worth noting that UK has actually been having problems sending vignettes and passports in certain areas. You can certainly attempt to contact your VAC to check whether courier return is available, but I think this is more just something to be alert for, at least in certain regions. Of course, applicants who are looking at ILR or naturalisation and who are trapped outside the UK and unable to re-enter will be very concerned about the impact of excess absences on any future application. As everyone here will be well aware, the Home Office, of course, has a discretion to waive these, and certainly speaking from my own experience, is not always generous in exercising that discretion. Therefore, when any of us come to advising on one of these applications, I thought it might be helpful to remind the Secretary of State of what her Undersecretary Kevin Foster said in answers to parliamentary questions on the 23rd of March. This was in the context of Tier 4 applications, but to my mind, it has general application. So he states quite unambiguously that we are very clear that no one will have a negative outcome in the immigration system due to a circumstance that was beyond their control. And that's perhaps a quotation that it may be useful to make use of elsewhere, not just in excess absence cases. So I'm going to move on now to talk about applicants in the UK. The first concession, which we've already touched on, is the temporary extension scheme. So this was originally introduced, as Adrian said, for Chinese nationals, but there's now no nationality restriction. So for any national whose leave is expiring between the 24th of January and the 31st of May, and who is unable to leave the UK due to the COVID travel restrictions, or because they're self-isolating, they can apply. Adrian's right to say it's not, strictly speaking, an application. It's a free online form which is sent to the coronavirus immigration team, explaining the reasons why the applicant is unable to leave the UK and requesting an extension of leave. Some practitioners have been rather concerned that you don't receive a BRP as a result of this. There's simply an email confirmation from the CIT. But in terms of the concerns about the impact which this extension might have on future applications, the Home Office does at least attempt to reassure us on the relevant page, saying that anyone who applies for and obtains a temporary extension will not be regarded as an overstayer or suffer any detriment in future applications. That again might be language that we might want to bear in mind if we run into difficulties for clients in future. Of course, this is a temporary extension scheme, and it's not intended for those who plan to stay in the UK long term. We'll come on to talk about them shortly. However, I have come across some practitioners who have been making applications under this scheme for clients who are not currently in a position to be able to put in an application for a longer period of leave as a stopgap to avoid a brief period of overstaying between applications. Of course, we're rapidly approaching the 31st of May. I think most practitioners anticipate that this scheme and the other schemes set to be expiring on the 31st of May will likely be extended. I understand that the government will be making an announcement regarding extension of coronavirus restrictions this Sunday. And if they are to be extended, as I imagine they will be, it would, to my mind, be highly likely that the Home Office will be extending these schemes. So this is an excerpt from the relevant page of Home Office guidance to which I referred at the beginning of my talk. The reason why I'm drawing this to your attention is that the section underlined in blue, referring to updating your records with the coronavirus immigration team, that is the link in the web page that you want to use to take you through to the relevant form if you're applying for a temporary extension of leave under this scheme. I want to very briefly mention the slight change that's been made for Tier 1 entrepreneurs. This form of leave has been given a slight new lease of life for those visa holders who are currently unable to comply with the employment condition that they employ at least 2 people for 12 months. Particularly because any time when their employees were furloughed won't count towards that 12-month period. So if Tier 1 entrepreneur visa holders haven't been able to employ staff for the requisite period, they can temporarily extend their visa to obtain time to meet the requirements. And that isn't limited to the 31st of May. That's simply where you can meet those other criteria that I've just referred to. So we've talked about the temporary extension scheme, but if you are an applicant with leave in the UK and you want to switch on to a longer term form of leave, the significant concession that's been made here is that for anybody who is applying for leave, which would normally require entry clearance or an out-of-country application, that requirement is now being waived. I've set out the details on my next slide. Provided you apply online by the 31st of May, if your leave is expiring within that period since the 24th of January, you don't need to fulfill the entry clearance requirements. However, you of course have to meet all of the other requirements and pay the requisite fee. Now, to move on to a slightly more generous concession that's been made, I've quoted here from the Home Office announcement, as was initially made, when Priti Patel indicated that NHS frontline workers would have their visas automatically extended. Since that time, things have moved on and this concession has become somewhat more generous. So the Home Office has agreed to automatically extend leave for NHS workers and those working with independent healthcare providers, provided they can show that they're in what's referred to as an eligible profession. In order to be eligible, you have to have leave which is due to expire before the 1st of October this year. If your leave is extended, it will be for a period of 12 months for both yourself and any dependents. This is free. They aren't required to pay the immigration health surcharge. As I've said, it's automatic. The idea is that the Home Office and Human Resources at the relevant employer will liaise to confirm whether individuals are eligible, and anybody who would wish to benefit from this scheme is being told to contact their Human Resources department. I think it waits to be seen how that may work in practice. Once the Home Office has confirmed that somebody is eligible, they'll be notified and are to send their BRPs to UKVI. The perhaps interesting practice point here is that if you have a client who would otherwise be eligible, who's put in a paid extension, provided they haven't yet sent in their biometrics, you can withdraw the paid extension in order to benefit from this free scheme. And you can do that by email the address that's there on the slide. So, crucial question, what's an eligible profession? In the slides that I showed you at the beginning, it was indicated that this scheme would only benefit paramedics, doctors and nurses working in the NHS. Also, due to a link to some of the Tier 2 guidance on the gov.uk website, some practitioners thought that this was only applied to Tier 2 migrants. However, it's since been clarified on the 29th of April by both Matt Hancock and Priti Patel that the scheme will include both NHS and private healthcare workers. And it's not restricted merely to doctors, nurses and paramedics, nor is it restricted to Tier 2. You can find the full list of eligible professions on the gov.uk guidance that I've already referred you to. I've set out the full list here. And I think there are two interesting things to note. Firstly, this is a pretty broad category of individuals. You might note that social workers are in there. You might note that plenty of healthcare professionals who may not be working in any way directly with COVID patients can benefit, so dental practitioners, podiatrists, for instance. There's also a couple of categories which are potentially quite broad. You can see in the first column a reference to health professionals, and secondly, in the right-hand column, a reference to therapy professionals. And these are potentially quite vague terms that could do with a clearer definition. That's the principal concession for healthcare workers and the automatic extension of leave. But there are also a few more changes that have effectively been made on a pragmatic basis in order to enhance capacity in healthcare services at present. So the restrictions on the numbers of hours that individuals can work or volunteer have been removed for these four categories of individuals who are working in healthcare. So we're thinking here about student nurses and doctors. We're thinking here about Tier 2 workers who hold a second job in, I've referred to it as an NHS job, but I should say a healthcare job. It can also encompass short-term visa holders who've been allowed to volunteer in one of these roles. And then quite a discrete category, pre-registration nurses. The deadline for them to sit their exams has been pushed back to the 31st of December this year. And Priti Patel explained that that was explicitly to allow them to focus on beating COVID. So before I close, I'm just going to talk a little bit about the Coronavirus Immigration Help Centre. I'm sure that plenty of those attending today will have already had some contact with the Help Centre, and I've certainly had a variety of responses from those who have done so. It's been set up to deal with immigration queries related to coronavirus. The principal method of contact is the email address you can see there on the screen, which is supposed to provide a response to any queries within 5 working days. I understand in practice this often looks more like 2 weeks. But I haven't heard of any cases much longer than that. Perhaps there are some people here who've had more serious delays. I've also heard mixed reports of the quality of the responses. I've heard that potentially there's been some improvement recently, but certainly there have been some complaints about poor quality responses. There's also the telephone helpline, which is free to use, but unfortunately only provides signposting. So any substantive queries, and of course, for instance, things like the casework queries that might come up will have to be emailed, and hopefully you'll not fall into one of these poor quality responses that some of my colleagues have seen. So thank you very much. I'm now going to hand over to Mark and stop sharing my screen.
Thanks very much for that, Miranda. That's an excellent oversight of many of the general considerations. So I'm now going to discuss some of the commercial immigration routes in slightly more detail. So starting off with entrepreneurs, as we all know, there is now significantly more difficult situation for entrepreneurs who face job creation requirements under the current crisis than perhaps there was previously, just as a matter of general economic self-evidentness. The entrepreneur route demands that you create 2 extra jobs which have lasted for 12 months each, and the requirements, the detailed requirements of that are laid down quite clearly in Appendix A in Table 5, at the back end of Table 5, where the 4th and final requirement basically explains that you have to have created 2 new jobs for a new, or added 2 new jobs for an existing business, and that you have to have maintained those jobs, including 12 months in the last grant of leave. And obviously it's the requirement to have employed 2 people within the last 12 months of your leave, which raises the possible problem here, because one can well imagine that if someone was relying on, within a 24-month or a 30-month grant of leave, a 12-month slice of time, which wasn't completed in terms of a single employee's employment by the beginning of the COVID meltdown, they're not going to have their 12 months in the bank. And that's obviously a problem. So what does the Home Office have to say about this? And this little job creation concession that Miranda touched on is actually found in the mainstream guidance, the most basic bit of guidance on the Home Office homepage. And it has 3 paragraphs. And the first paragraph says you no longer need to employ at least 2 people for 12 consecutive months each. The 12-month period you require to employ someone for can be made up of multiple jobs across different months. Okay, well, that's interesting, isn't it? But of course, what is that passage? What does it mean? Because we knew that anyway. That was the existing system, yeah? The existing system didn't require 2 people to be employed for 12 consecutive months each. Even immigration rules tell us that, Appendix A, paragraph 49. So it's not really clear if that first paragraph is a new concession, which obviously is what's suggested by the phrase no longer need, or is it simply intended to be a general summary of the existing position, which is inconsistent with the phrase you no longer need. Who knows what's in the mind of the Home Office? What is clear is that there's a problem with furlough, yeah? So furlough is when your employees are stood down under the scheme, now a formal scheme, best to do it in writing and so forth. Time when your employees are furloughed will not count towards a 12-month period. So it's quite clear that furlough, as well obviously as outright redundancy, will exclude your employees from qualifying towards your extension or ILR application. And then here is what is plainly a saving grace. If you've not been able to employ staff for 12 months in total by the time your visa expires, you'll be allowed to temporarily extend your stay to give you time to meet the requirement. So, as my next slide shows, I mean, there's a tension in the language there. You could construe it as some suggestion that they're letting people off in the opening paragraph. More likely overall, I think, reading it sensibly, is that all they're really saying is that they're going to let you off the hook to a very limited degree, in that you can apply for an extra spell of limited leave, and during that extra period, hopefully you will satisfy the job creation requirements, because now by the end of the extra period of leave, you'll have 2 qualifying workers, each with 12 months in the bank. So that's my suggestion on entrepreneurs. My other topic I'll just quickly touch on, innovators. Innovators is a bit more straightforward, of course. So the starting point with innovators is that they have endorsing bodies, and the endorsing body has guidance to help its consideration, and it's told that it has its own measures of what makes a good business idea and the freedom to apply these criteria as you think best. And also endorsing bodies have checkpoint duties after 6, 12 and 24 months, and they have to check whether or not their sponsored migrants, their endorsed migrants, have continued to work and demonstrate reasonable progression, either in the original business or in a new business. And if it's a new business, they have to demonstrate that it's innovative, viable and scalable. So what do the new provisions tell us? Well, firstly, it requires sensible, candid discussions about the reality of current plans. So the endorsing body, and this is a situation in which only about a dozen applications have been granted in a year anyway. So I mean, this is not a large class of people set to benefit from the extension of this. But even amongst that restricted, lucky category, the endorsing body is now told to think twice about the reality of the current plans. Also, if the endorsement's been granted, but no visa application's been made, then again, there's a bit of a discretion there, as stated on the screen. What about those people, visas granted, but applicant unable to travel? Now, this possibility just cross-refers to the general COVID guidance, which basically says you should make your application as planned, and the UKVI will consider all applications on a case-by-case basis. Checkpoint pending. So if you've got one of your 6-monthly or 12-monthly checkpoints coming up, then these should be maintained. No need for a face-to-face meeting, but phone or video conferences is required. Allowance should be made for the present situation, so it's perfectly understandable that things were on ice for a while, but future contingencies must be discussed. So, everyone's going to have to face up to the fact that the world economy is about to have a crash that's not seen in, for a very, very long time. Extending leave to remain, whether you're still able to switch into startup into the innovator category, you can still upgrade from the former to the latter, but the current context again has to be taken into account by any endorsing body that's looking at these applications. So it can be very important for the endorsing bodies to keep good records of this, and just to make sure that they don't rubber stamp the ongoing viability of the scheme, but rather that they take a sensible contemporary approach. Thank you very much for that. I'm going to clear the stage now for Emma to take over.
Thanks, Mark. I'm just going to share my screen. Okay. Thank you. So I'm briefly going to look at some of the practical issues that are being thrown up in terms of testing and certificates. And we've already had some discussion in the chat about how to manage these situations with pending applications. Briefly looking at biometrics, which is something that Miranda's already touched on. The Home Office published guidance on the 24th of March. It's worth checking the webpage quite frequently because, as has already been indicated, it is regularly being updated by the Home Office with various bits of new guidance. But in summary, for in-country applicants, we're aware that centres have now temporarily closed. It's not possible to book a new appointment. If a client has an existing appointment, they should be contacted by the centre and informed that their present appointment's been cancelled and they should be offered the opportunity to book a new appointment. I understood from some of the discussion on the ILPA Google groups that a lot of applicants had been contacted to say that their appointment was cancelled but not offered the opportunity to book a new appointment. So that might be something that needs to be followed up. In addition to that, the Home Office guidance says, as has already been flagged by the speaker so far, that they hope that people's immigration status should not be prejudiced by the fact that they're not able to attend an appointment. So it's worth bearing that in mind if you're having any particular practical issues in terms of accessing appointments or testing. And for out-of-country applicants, it's also the position that visa application centres are closed. And similarly, the applicants should be contacted and told if an alternative appointment can be booked. So moving on then to Life in the UK test. My understanding from the most up-to-date guidance from the Home Office is that the centres are closed until at least the 11th of March, but that after the 11th of May, they should be able to book new appointments. However, I think it's worth being aware that they've already moved the time frame. So it's worth being cautious, I think, about whether 11th of May is a realistic time frame, because previously I understood it was the 1st of May and it's already been pushed back. One of the questions I think that Rosie had in the chat was a common query I think that's cropping up is what to do if a client has a pending application and needs to do the Life in UK test. It would be my suggestion that you should go ahead and make the in-time application and try to apply for a slot for one of the upcoming tests after the 11th of May. And if necessary, think about making representations to the Home Office about why it's not been possible to comply within the time frame. And hopefully no enforcement or any kind of compliance issue should be taken by the Home Office in that respect. Moving on then to English language testing. I think Adrian flagged already that the centres are closed, and so it's helpful, I think, to look particularly at what IETLS has published on their own website as recently as last week. They've introduced an online tool to help students progress their studies remotely, which might be helpful for cases where perhaps there's an upcoming test that has to be completed. And in addition, they've also put out a memo on the operational side in terms of what their centres are doing. The list of countries there is being regularly updated, and I think it's also the case that you'll see that with other issues like TB certificates, unfortunately, there's nothing firm from the Home Office at this point. My understanding is that they are seeking to review the position, but it's very likely that individual clinics in different countries are going to be impacted by the ability of clinicians to test for things other than COVID at this time. ATAS certificates are currently unavailable and the centres have been closed, and apparently the scheme is set to reopen as soon as possible, but unfortunately there's no more certainty than that. Similarly with criminal records checks, ACRO, however, has said it's still open for business, and we've provided the link here on the slide. The Met Police has indicated that OVO is going to remain closed, but that no penalty action will be taken for those who are unable to book a new appointment or attend. Moving on then to look at hostile environment checks, in particular work, study and rent. On this slide, I've just flagged the statutory and policy guidance in respect of the right to work in outline. The reason I've flagged the key guidance documents is that it's important because employers are going to be expected to revert to the original process once COVID-19 is complete. You'll have seen already, Miranda and Adrian and Mark have all flagged that Home Office website has been updated to include these landing messages so that employers are quite clear that actually there's a temporary process in place. The temporary process that the Home Office have implemented is to somewhat a degree a relaxation of the requirements, but it's important that checks are still carried out, but they can now be carried out either by video call or through the use of other remote technologies. For example, if you've got original documents that can't be checked, these can now be emailed, they can be photographed and sent to the employer. If it's not possible for an employer to use either of these mechanisms in order to check documents, then they should be using the employer checking service. The Home Office guidance note from the 30th of March includes in it a kind of prescribed step-by-step process as to what they require for a right to work check during this time. As you'll see, that one of the things that is really important from a compliance perspective is to make sure that records actually reflect that an adjusted check was undertaken on a particular day due to COVID-19. Similarly, I think it's important just to flag that if the person doesn't have documents, again, just to be signposting clients to the employer checking service. Whenever COVID-19 is over, which unfortunately nobody knows, the Home Office have indicated they will contact employers in advance to tell them when the temporary measures are likely to end. And so after that date, employers will need to revert to the process that's set out in the right to work checks in the employer's guide. Employers will need to undertake retrospective checks, particularly in two categories: for any new starters that started after the 30th of March, and also for any existing employees that required a follow-up check from the 30th of March. Retrospective checks will need to be carried out within 8 weeks of the temporary measures being cancelled. And again, the Home Office also require that employers include prescribed kind of wording in their record. So it's important to emphasise that their record keeping reflects the need that they've taken an adjusted check and then they've followed up with the retrospective check. Moving on then to the right to study, Adrian's already flagged the changes for the Tier 4 route. The new guidance was published on the 20th of April, and again, it contains the same statement of purported intent that Miranda has flagged, which is that ministers are very clear that no one should have a negative immigration outcome because of circumstances beyond their control. And that's, again, I think something that we just need to be mindful of if there are issues in terms of complying with deadlines or firefighting queries with the Home Office. The guidance contains temporary policy concessions for the Tier 4 route. And the Home Office have indicated it will be kept under regular review and it will be withdrawn when circumstances return to normal. It's required to be read in line with the existing guidance. So I've just flagged these here for you, but I'm sure you're all familiar with the various documents. In terms of meaningful content then for the purposes of COVID-19, obviously Tier 4 sponsors are required to take steps to ensure that their institution has a system in place for checking that students do have the permission to study. What's contained in the new temporary guidance is a relaxation of that to the extent that it recognises that sponsors won't need to necessarily see original documents and that these can perhaps be carried out through remote technology, again, emails and photographs. So it's a similar kind of relaxation as we see with right to work and right to rent. Moving on then to the right to rent. Again, I've just put the key statutory provisions in the guidance documents on this slide. I've also flagged, just for current awareness, the recent JCWI challenge that's been in the Court of Appeal in the last week has concluded that although the scheme does cause discrimination, it's capable of being operated by landlords in a proportionate way and was justified. I understand that JCWI are appealing this to the Supreme Court, so that's maybe something to keep on the radar, particularly if you're advising clients about issues to do with discrimination and avoiding discrimination. Again, we've seen the Home Office have tried to flag that they have implemented a temporary process for COVID-19 for the right to rent. The guidance, again, published on the 30th of March, is similar in terms of its content. Checks can now be carried out over video calls. Tenants can use either scanned documents or photographs of documents for checks. And equally, if landlords cannot practically check the documents, they're signposted to go to the landlord's checking service. And it's important to remember that checks are still required. So landlords do still need to comply with what's in the Code of Practice and the User's Guide. It's just that the mechanisms by which that they can comply with that are slightly adjusted to reflect the fact COVID-19 is impacting face-to-face. Again, the Home Office have indicated the step-by-step process they expect for a temporary right to rent check. Again, it's important to flag that clients will need to include a record to say that an adjusted check has been undertaken. In terms of what's going to happen in the future, again, the Home Office have indicated that when the measures come to an end, they will notify landlords, and landlords will need to go back to the checking process that's outlined in the Code of Practice and the User's Guide. As with the right to work, landlords will need to carry out retrospective checks for people who've started tenancies either within the period or who need a follow-up check in this time. And again, helpfully, we're seeing the same messaging, final bullet there. The Home Office have stated that they will not take any enforcement action against anyone that's complied with an adjusted check and then carried out a retrospective check. So it's perhaps a small measure of comfort, but it seems to be the Home Office are acknowledging that there is unprecedented difficulties facing landlords at this time. In terms then of just practical issues to bear in mind for compliance, obviously record keeping systems are obviously always really important, but I think particularly now, clients need to adjust their systems so that they can just simply have a note to flag when they've undertaken a check that's adjusted for COVID-19 or it's a temporary follow-up check. It's important to encourage, I think, clients to get used to using things like Zoom, Microsoft Teams, Skype in order to make the most of the remote solutions, and also to keep an eye on the Home Office web pages, because it seems that they're using their web pages to deliver a lot of this ad hoc guidance rather than a coherent published policy document. And again, it's being updated almost on a sporadic basis. There's no rhyme nor reason. And then finally, just practical issues in terms of encouraging clients to be proactive if they do have questions and to make contact with the coronavirus helpline, as Miranda has indicated. And then finally, I just wanted to touch on, just for completeness, as we raised the hostile environment was the NHS charging. Essentially, on the 29th of January 2020, a new statutory instrument came into force that added COVID-19 to the list of diseases where there will be no charge on the NHS. There's also detailed guidance from the Department of Health and Social Care to the NHS, And essentially the point is that no one should feel discouraged or deterred from coming forward because of their immigration status. I've just flagged for perhaps discussion later down the line, but we might be seeing generally a groundswell of opinion that this is unworkable. In fact, that's one of the things that the Royal College of Paediatrics is suggesting. So that's everything from me. I'm going to stop sharing my screen now and hand back to Adrian.
Thank you. I'm just going to get my screen up and running, and then we are going to go on to look at the question of the settled status scheme. Just bear with me a second. So, and just to note, actually, in the meantime, of course, that the hostile environment also, of course, continues in respect of applications for driving licenses and bank accounts and so on, and that there's been no particular notification over that. When we come to look at the Home Office response, generally, it's really striking that the response of the Home Office across all of these areas that we've covered so far has been very, very piecemeal. There hasn't been any broad brush approach towards lifting restrictions, either in respect of the hostile environment or in respect of no recourse to public funds restrictions generally, nor has there been any general uprating of in-work benefits for those people who might be otherwise ineligible for them. And that's one common theme. If you're looking, obviously the focus today is on economic migration, but a number of people on whose visas are due to expire may have no recourse to public funds endorsements put on their visa entitlements, which may and they may need to lift those in order to have access to in-work benefits as a result of a reduced wage situation. So watch that space for the test case litigation which is going on in respect of that. So the question, and my slides have gone slightly astray, I know, despite the best laid plans. So the question in respect of the EU settlement scheme is what's happening now. And we have, if I just bring you to the slide, we're almost there. The main thing is not a great deal is happening, except if you happen to have the misfortune to be a third country national or be in respect of a non-biometric passport. So there are no changes made in terms of the settlement scheme to applications through the EU Exit document check app. However, the telephone line has been closed, or the EU SS Resolution Centre telephone line has been closed since the 25th of March. It is possible, of course, still to use the online contact form, but responses take longer than 5 working days. And of course, you can expect a lot longer on decision times as well. There is an injunction that's gone out, or an exhortation, not to send original documents by post unless requested, obviously, because one of the things is, of course, that a lot of post is simply ending up in mail sacks and undelivered, or if it's delivered, there is no one there to open it. And it does create a real problem where original documents are sent. The key thing, in addition to that, which is of real significance for third country national family members, for non-EEA family members, is that applications cannot be completed online. That creates a problem because, of course, you need to request paper forms from the using the EU SS Resolution Centre contact form. There are a couple of problems that arise in relation to that. Is what do you do in that situation if you can't make an application via the online procedure? One of the things is, of course, is that you can always try and use the procedure that's available for applying for a residence card under the EA provisions. So, of course, as we're in the transition period at the moment, if you're reaching a situation where you cannot make an application for settled status as a third country member, whether or not you end up with pre-settled status or settled status, there's still this other procedure in order to obtain residence documentation, which is enforced until the end of this year. And that's the good old EEA application for a process for receiving, if you're an EA national, registration certificates, and a non-EA national family member, a residence card. And so if you apply for it as a third country national family member, for a residence card, and that procedure is still available, you will get a letter back saying that you have made your application, and that you should also be looking to make and that will also give you confirmation that you're allowed to work, which may of course be critical at this time. The same sort of problems which exist with respect to third country family members, but that generally also exist for those who are seeking to do things which have only ever been in terms of paper applications only, so for derivative rights of residence, or for those on the Surinder Singh route as family members of British citizens or other British nationals who qualify as UK nationals for EU law purposes. And so you have a situation where although it's not possible to make a paper application at this time, you can request a form from using the contact form, the email contact form. You can request an application form, and you can prepare the application form in anticipation of being able to send it. And one particular thing which might be a good idea then is to scan and email it to them anyway, and to see what happens. It's and then see if there is some flexibility in considering the application in that process. If it all sounds a bit hit and miss and a bit ad hoc, that's because it is, and the fault lies with the Home Office in not making a straightforward family members, or for those in possession of non-biometric documents, or for those using the derivative rights routes or the Surinder Singh routes, to have a straightforward and easy way to make their applications online and to supply the necessary copies of the documentation online. The exhortation is not to send, I'm sort of keeping one eye on the chat as I'm saying this, the exhortation from the Home Office is not to send original documents unless requested to do so. So perhaps in a nutshell, unsurprisingly, the routes that the Home Office feel are most difficult from their point of view in terms of rights of residence, which they are reluctant to encourage under EU law, are those for whom it's upon those people that the most complications in terms of continuing to make applications during this crisis fall, and that they have the most difficulties in pursuing their rights. That doesn't, of course, stop any of us from advising them. It doesn't stop any of us from taking a belt and braces approach towards trying to encourage them to make to secure paper application forms by using the email contact form, and also to try and send them electronically by way of reply. Whether or not that's sufficient is a different matter. One thing to bear in mind, apart from extended family members such as unmarried partners and so on, is that of course it remains the case, as we're in the transition period, that EU rights arise as a matter by operation of law. They arise directly, and what we're talking about, of course, is the documentation to evidence them, not the grant or the source of the right. So if you're looking for advice to clients in this situation, EU law still applies during this transition period as a result of the European Union Withdrawal Agreement Act 2020, and that what you're advising clients, of course, is in the context of documentary proof of rights of residence if you're not going through the settled status scheme, if you're, and that those rights, those that have them, which have rights under EU law, will have them. Of course, what we will have is a situation where those who might be applying for settled status under Appendix EU are really divided into two classes of people. There are those that would have had rights under EU law in any event, and they have rights arising by operation of law. And there are those, for example, because they're not otherwise self-sufficient, or they don't have comprehensive sickness insurance, and they're not economically active either, or the principal EU citizen isn't, and therefore the family members get no family reunion rights. Those people who might have benefited from the settled status scheme, if they're third country national members and can't apply, won't be able to go to apply for an EU right of residence card document because they don't qualify under EU law. So it's really that class of people who are in a narrower and more difficult situation. But for those that do have rights under EU law who are prohibited from turning towards the settled status scheme at this time because they're third country national family members, and for making an easy application, the EU route still applies. So, and it is worth exploring, of course, if for nothing else, it proves that you're here lawfully. But don't forget that that people who have rights under the EU treaties still have them, regardless of their documentation. So that's all I have to say on the settled status scheme. We have about 23 minutes left of our seminar. We're going to hear from Mark now on public law principles to be applied in the context of this. So Mark's going to speak for about 10, 12 minutes, and then we'll have time for questions at the end from people. We can either deal with them in the chat, or we can, if you want to speak either just by audio only or by audio and video, we can promote you through the Zoom channel itself, and you can give ask your question orally. Thanks very much.
Thanks very much for that, Adrian. Yes, I am indeed going to do my session now on the public law dimension, and then immediately at the end of my session on that, I'll answer a question. Well, answer may put it rather high. I'll address a question that's come on the entrepreneur route. Okay, so public law principles and Home Office concessions. So to start off with, there's always a discretion to depart from the rules. And this has been heavily litigated in the context of the points-based system. We have an immigration web of legal provisions, which starts off with statute, and then most of it's actually set out in the rules, and it's explained and glossed by Home Office guidance sometimes, which is largely consistent with the rules, sometimes expands on the rules and fills in the gaps. And the Home Office policy is something that's tremendously, been tremendously important in immigration in recent years, in terms of providing the opportunity to make up for gaps in the rules with a little bit of equitable thinking to help people who'd otherwise have badly lost out because of the harsh ways in which the rules can operate. You can see perhaps the most important policy position, the summary position that the Home Office have put out, is this phrase: no individual of any nationality whose leave has expired or is due to expire between 24th of January 2020 and 31st of May 2020, and who cannot leave the UK because of COVID-19, will be regarded as an overstayer or suffer any detriment in the future. And there's a tremendously broad statement of policy. And it's interesting, I think one of the questions that was put by Matthew Davis, I think, in the chat that I spotted a few moments ago, raised a question about, is there any specific material about people whose ability to meet the continuous residence requirements of the economic migration route is threatened because they're going to clock up excess absence, i.e. absence beyond 180 days in a calendar year, forced on them by COVID-19 travel restrictions. And I'm not sure that there is any express answer from the Home Office on that particular problem yet. But what about this general policy position? It's promising in terms of a general statement. The only downside, of course, it's got that phrase, who cannot leave the UK. So it may well capture people whose individual circumstances aren't dealt with whilst they're in the UK under any of the Home Office policies that everyone else has taken you through. A bit harder to see it operates for someone who's outside the UK. But it just shows how important it is to read every word of each of these concessions. Abdi and Nadaraja, the late early victim, sadly, of COVID-19 just a few weeks ago, the great Sir John Laws, public law legend, he wrote that a public body's promise or practice as to future conduct may only be denied in circumstances where to do so is the public body's legal duty or is otherwise a proportionate response. So Home Office aren't allowed to go back on their statements unless they've got a very good reason to do so. Very hard to imagine how that could apply in the context of the current crisis. Mandalia tells us that the requirement of good administration is for public bodies to deal straightforwardly and consistently with the public. And also, here we are, this is how up to date we are. Just from a couple of days ago, Alliance of Turkish Business lost in the Court of Appeal, sadly, the case about the legitimacy of the Home Office changing the settlement route for Turkish workers who believe themselves to have been protected by the long-standing position that they get settlement after 4 years leave as a worker. They all got booted back onto 5 years settlement route. Court of Appeal upheld that, but along the way, the Court of Appeal said that even where relevant statements made by a public authority on a mistaken view as to what the law is, doesn't stop you being able to rely on public expressions of guidance. And who knows, that could be important given the difficulties that Adrian pointed us to earlier in terms of reconciling some of the Home Office generous statements online with the strict letter of the law. Something else about guidance is that it's to be interpreted in a common sense way, and this comes from the famous Pankina and Alvey litigation. And so in these cases, of course, we learnt that strict requirements should always go in the rules. And obviously, of course, there's no sign in the in the current bits of guidance that have come out. There's no danger of over specificity, as we'll come back to in a moment. The entrepreneur guidance is one struggles to really comprehend their meaning, so it's certainly not over precise. Anyway, Pankina told us, as well as telling us about the fact that strict requirements had to be in the rules, it also told us that a policy is not a rule. It's required by law to be applied without rigidity, to be used and adapted in the interest of fairness and good sense. So again, that's a reminder that the policy that we've seen, including the general position that no one is to be prejudiced by the current crisis if they're in the UK, well, query, does this legal principle suggest then that that should be adapted in the interest of fairness and good sense to the people trapped outside and whose excess absence is now threatening their ability for a future RR application under the PBS? Generally speaking, though, under public law, leaving too much to government discretion is not thought to be a good idea. As one judge famously says, to remit the maintenance of constitutional rights to the region of discretion to shift the foundations of freedom from rock to sand. So, there was a worry here that these generous positions are all well and good for so long as everyone's in the right frame of mind, but we all know that the Home Office memory isn't perfect. Windrush is a particularly graphic example of that, but loads of people will have seen cases over time where policies that everyone thought were happily in place and understood somehow slipped from the Home Office institutional memory. Of course, the Home Office has to take account of her own responsibility in any future decision making. EK Ivory Coast explains that to us. So where it's third-party error or problems, then the Home Office doesn't have to worry about it. But anything that the Home Office has done or said has to be taken into account in her own decision making. And of course, in the economic migration route, we're reminded UE Nigeria tells us that whenever the public interest is looked at in those cases, the fact that someone's of value to the community goes to the weight of the public interest in the proportionality exercise. It may be that some people, hopefully everyone will get fast, speedy saving graces under the immigration rules and the relaxed policy situation, but if not, they may have to rely on human rights appeals in the future. And I can certainly imagine that for years to come, we'll be looking at gaps, ostensible gaps in leave or excess absence. And the argument being put will be that it can be papered over by applying a broad approach to Article 8 ECHR. So if people have got enough UK ties by way of private life, and of course, remember, students, we're told now, students and workers, Arsan and Balajagari have made it pretty clear recently in the Court of Appeal that anyone who's been here in a professional capacity, making links beyond their job and course with a professional identity for an extended period of time, they're probably going to have Article 8 rights established. Home Office policy positions have to be taken into account, says the case law, when assessing the proportionality of outcomes in any particular case. Adrian's already dealt with my final slide really in adequate detail, in excellent detail, in fact, and it made all the points that really need to be made about the tension between the generosity of policy and the strict letter of law, and the fact that this tolerances don't seem to bring Section 3C leave with them and have problems about the form of notification of the extension. Before I leave you, let me just have a think about one of the questions that was put on the entrepreneur route in the chat. Johnny Nash once sang, there were more questions than answers, and he could certainly have been singing about the Home Office guidance. He says that, so yes, the question was put, really, essentially, this is what made me think about it, was that there's is there a double discretion? Is it not just simply an ability to make an application for kind of sticking plaster leave until you satisfy the 12 months requirement for 2 separate workers? That's how I rather thought a judge would look at it, but who knows? Let's look back at that. So the concession says you no longer need to employ at least 2 people for 12 consecutive months each. The 12-month period you're required to employ someone can be made up of multiple jobs across different months. Different jobs, and then the rule says different jobs that have existed for less than 12 months cannot be combined together to make up a 12-month job. I don't know. So, I mean, when the Home Office refer to multiple jobs across different months, are they intending to relax the rule that referred to different jobs that have existed for less than 12 months? You could certainly argue, I mean, you could certainly get a JR out of it. Whether or not you'd ultimately win your JR, I don't know. But in the current climate, the lack of clarity and judicial sympathy for the current situation is going to be on your side. So I can see that. I can see that as being arguable. So interesting, I mean, every time you look at this vague guidance with a fact pattern put in front of you, your thinking on it tends to change. Okay, I'll hand back to Adrian now, and I'll stop sharing my screen. Thanks very much.
Thank you, Mark. Just before we go on to questions, we do have just a couple of observations. Gabriella put a question in the chat, actually, which about naturalisation, but it just reminded me that we ought to just deal with that issue briefly about economic migrants who are on a path to settlement and naturalisation, and excess absences or technical absences as well in the context of naturalisation, which is of course where you remain in the country but your presence is to be disregarded and treated as a technical absence for various reasons. And I think if we start just note briefly about applications for naturalisation for economic migrants, is that the statute provides, the British Nationality Act, it doesn't provide, it's not interested in the reason for your excess absence or for your technical absence if you're in the UK. You're either present for the requisite number of times or you're not. And of course there is a discretion to disregard excess absences or to disregard technical absences. And one of the reasons for it is for reasons because of travelling for reasons of business is one reason. And there's a slide, and another one is for compassionate reasons. And then as you move from excess absences of more than 450 days in a 5-year period, or 90 days in the final year, which is about a quarter of the time, through to about half the time, then discretion is likely to be exercised. But if your excess absences are for greater than half the time that you're supposed to be in the UK, then it's very unlikely that discretion will be exercised, although the policy to disregard excess absences still applies. And by the time you get to being away for more than 3/4 of the time, it's almost impossible to disregard the excess absences. So that's the sort of tariff that applies in naturalisation cases anyway, up to a quarter of the time, possible, probably probable, if you've got a good reason for commercial or compassionate reasons, up to half the time, possible, more than half the time, you can try your luck, but see where you go. In that context, if you're absent and you're being pushed up towards one of those barriers as a result of being unable to travel because of COVID-19 or self-isolation, you need to make representations as to why that extra period of time makes the difference, because it's not just totaling up how long your period of time, how long your excess absences are, but whether it takes you into one or more portion of the policy, because of course the longer you're away, it might just tip you over into being away for more than a quarter of the time or more than half the time, and that could be critical in terms of how discretion is to be exercised to disregard excess absences. So bear in mind, for naturalisation applications for economic migrants, you're not just dealing with the gross number of days in which you've been absent or technically absent, you're dealing with whether or not it unfairly pushes you into a different aspect of the policy to disregard excess absences. And so, and that can make a lot of difference, because obviously the criteria for naturalisation in terms of disregarding excess absences are different to those which apply for disregarding absences for the purposes of getting indefinite leave to remain in a tier 1 category, for example. The 450 days across the 5-year period is different, obviously, from being away for up to 180 days in a 12-month period, for example. And so you've got to keep your eyes on both. And that there's been, as far as I've seen, there have been no updates on disregarding excess absences for naturalisation purposes as a result of the crisis. But we should be expecting them to consider those applications sympathetically. So with that in mind, that's naturalisation. Do we have some questions that people would like to ask live? We've got 8 minutes in which to deal with questions, any and all questions on all of the topics that we've covered, or none, potentially, as long as they relate briefly to economic migration or tangentially, and to deal with any practice points which may be coming up. So do ask your questions either in the chat or by, I think, by raising a hand on the participant list. Do we have one here? I see. I can't see everybody, so I'm not sure if anyone can. But I'm going to unmute to here. Can you? Yes, I think you've raised your hand.
Yeah. Can you hear me on?
We can hear you here if you want to ask your question.
Yeah,
well, hopefully.
Tahir Khan. Quick question is, I was asked about, we just heard about online applications. When it comes to life in the UK test application, certificate or English test, we need to fill out the relevant information from that. But without that, how we can submit online application?
Can someone take that while I just look at the participant list to see the number of questions we have coming up? Mark, I don't know if you're able to deal with that, or Miranda.
I'm so sorry, I was struggling to hear the question.
The question is life in the UK test and English test. If an applicant is unable to do due to COVID-19, in online application forms, there are sections which needs to be, which are mandatory sections which needs to be filled. So what would one can do about submitting the online applications? Because it doesn't allow you to move forward, to go on to submit an application without the relevant information, without inputting all the relevant information.
I'm aware from I think probably from reading the ILPA coronavirus group that some practitioners are getting emails from the Home Office in response, obviously in response to having made some progress with their applications. I'm not quite sure how they've got this far, telling them that the testing process are obviously on hold at the moment, and that they should provide a scan bundle and biometric details as quickly as possible just to keep their place in the queue. But otherwise, any contingencies will be addressed later. That's one suggestion I've
But
read.
What will happen to the application, submission of application? Because if someone's visa is running out, suppose spouse dependent or someone visa is running out on ILR, now how we can submit that online application without the information of life in the UK test, in absence of life in the UK test?
I think I might just, Mark, my understanding is that you can still book a forward-looking life in the UK test. So they have opened up slots from the 11th of May. So okay. if your client needs to do an application now or has one pending, you can go onto the Life in the UK portal. You can ask for a date after the 11th of May. And I would hope that because of the messaging from the Home Office that they understand there are practical problems, whatever information you get from that portal, you can then put in the application form to say that you've a test coming up in the, in the next month or so, and hopefully then maybe follow up with the Coronavirus Help Centre in writing to say, I've made this application with this reference number. As you're aware, my client can't physically go to the centre until lockdown's lifted. We have a slot on 12th of May. Please, can you look favourably on the application and ask for a response in that way?
Okay, because there's no, normally there are 15, 16 numbers, special numbers, which you need to insert in the application form. And if that is not correct, it's no longer like old forms where you could say, please see representation. Here, they are coded, computer coded. They don't even move to the next page. So that is the irony, but never mind, I will give it a go and see if it works. I thought I'd share the knowledge with everyone.
Sure, I can see in the chat that other solicitors are saying that they're putting to be confirmed or just putting like a blank entry in that field, and that's holding the position for now.
Okay, so that's good.
And
Thank you
Nargis, you're also saying that you'd found an option. I'm just going to unmute you.
Thank you. Hi there. Hi, everyone. Basically, I've done it for 2 spouse applications, and it asks you, do you meet the English requirements? So if you put in no, and you can then put the option there and explain due to COVID, the centres are closed. And then when uploading documents, I've been uploading the screenshots with the actual where the centre's closed and it's been postponed. So there is, if you put in no rather than yes, you can get bypass that and submit the application, which I've done on 2 occasions. So I hope that helps.
That's great. We do have time for one more question, I think, if anyone has a question. I can't see anything in the participants list of anyone's hand up. If anyone wants to ask a question, have we got Richard, I think. I'm just going to unmute you. Yeah.
Thank you. Thank you, Adrian. Are you seeing me?
Yeah.
Good. My question's of perhaps general interest, and it's the relevance of the Kevin Foster statement that nobody will be disadvantaged. Can somebody reflect on the position of a marital application where there is an Appendix FM application where there is a sponsor in this country whose income is going to fall below 18,600 on account of COVID, and who therefore won't be able to import his wife as he thought he would be able to. Has there been any evidence of the Kevin Foster statement applying to the Appendix FM rules?
Well, yes.
I haven't seen any general statement of it. I would obviously encourage, flexible approach. Mark, did you have a?
Yeah, I mean, that's right, isn't it? I mean, okay, so the residual saving grace in Appendix FM now is Gen 3.2, isn't it? Which is the thing that says that unjustifiably harsh consequences. And the Court of Appeal interpreted that phrase, unjustifiably harsh consequences, I can't remember, but in one of the 2 quite recent cases in January, I think, on Appendix FM and proportionality in the context of insurmountable obstacles, they said that that was an open balancing exercise, not really weighted in any way, and that any factors could be taken into account. So that statement, the government statement, would have to be taken into account by a Home Office decision maker, and then failing a niggardly refusal by the Home Office would have to be taken into account by the first tier tribunal on appeal.
Thank you.
Great. Well, we're at 12 o'clock now, which is our allotted time, and I appreciate everyone will have a number of commitments elsewhere in your practices. Thank you all very, very much for tuning in and for watching and listening to our webinar and to contributing. And thank you all very much as well for participating in the chat. To groupthink on solving these problems is always the best way to get through these things. The slides from the presentation will be made available to you all after the webinar, and also if you think of any questions between now and the end of the week that you wanted to ask during the webinar, and if any occurred to you afterwards when you get back to your other desk or wherever it is you're working, or probably the same desk, then do email us in, and we'll do our best to answer them. We do appreciate that having webinars in this way works in a slightly different way. So thank you all once again very much, and stay safe. Thank you.